Well, hello, boys and girls, and welcome to another scintillating, didactic, and provocative presentation involving commercial law and ethics. Well, it's sleeting here today, below 20 in gorgeous Vermtown, so we don't have too many students out there underneath the palm trees with their beach blankets, but nevertheless, it is President's Day, and we're all working. The purpose of life, right? Well, today we are talking about creating a negotiable instrument, boys and girls. And so we are talking terms of art here. And so these terms are important for you to understand, which is why we are addressing them. So let's first talk about something you may not have heard before, the term commercial paper. Well, what is commercial paper? Commercial paper is fundamentally a substitute for money. So let's take, for example, the contract that you sign to pay a monthly payment on a loan for your car. Now, that document that you've signed, that loan agreement with the creditor, becomes commercial paper in the sense the creditor can sell that loan document, that commercial paper, to another creditor for money. And so fundamentally, commercial paper are substitutes for money. Okay? So what are we saying about this? What we're saying about commercial paper is that there are some legal rights that go with the commercial paper. So under the law, under the Uniform Commercial Code, Article 3, the person who possesses commercial paper has an unconditional right to be paid. So let's say on that car loan agreement, if the paper is negotiable, and unless there is some provision in the loan document that would prohibit its negotiation to another party, it would be considered a negotiable instrument. Clearly, the instrument has to be negotiated to the possessor. So that is an assignment, for example, from one creditor to another, that the possessor is a holder in due course. And we'll talk more about HDCs in just a moment. That the issuer, that is the party that signed the document in this case, can't claim any number of a limited type of real defenses. We'll talk about those in just a moment too. Now, what's negotiable versus non-negotiable? You may have some substitutes for money that specifically state on them that they're not subject to negotiation. That is, that they cannot be transferred to another party and obviously cashed in. So it is, in fact, Article 3 of the Uniform Commercial Code of South Dakota, but which is identical to all other Article 3 provisions of other state Uniform Commercial Codes, covers two types of negotiable paper, notes and drafts. So what are they? A note is a promissory note, right? The loan document that I just referred to earlier, which is fundamentally a promise, right? A contractual promise to pay money. So who is the maker of a negotiable instrument or a note? Maker obviously would be the person, the debtor, who is signing the instrument creating the negotiable paper. Who is the payee? The creditor who is named in the negotiable instrument. What does payable on demand really mean? Well, it simply means that when it is surrendered to the maker, it is subject to being paid instantly. Um, you don't see many of those because most negotiable instruments have some time on them during which, um, while they have value, so let's take the loan agreement I mentioned for the purchase of an automobile, um, it would give a creditor the right to be paid by the debtor over a period of time and wouldn't be subject to automatic payment if the creditor surrendered it to the maker, even demanding so, unless the instrument were to provide for that specifically. A draft is an order directing another party to pay money for you. So, for example, a check, and we all have checks, right? Checks are drafts on our banks. Oh, so let's go through the process. We are drawing on our account. So the account holder, us, we, the account holders, draw on our bank account. Who is the drawee? The drawee, we are drawing it on our bank. So in my case, it would be First Bank and Trust. I would be the drawer. I'd be drawing on my bank to pay a specific party named on the check, who is the payee. So who is the issuer here? The issuer may very likely be the drawer or the maker, okay? Both the maker and the drawer. So what is a cashier's check and why is it used? Well, cashier's checks are bank checks, that is, banks that are issued by the bank, right? And a purchaser will purchase the check and obviously make it payable to another party. That cashier's check guarantees that there is money backing that particular check. Okay? So, drafts certainly can be drawn on non-bank accounts, like a company's own account. So it's not unusual, especially in international business transactions, for banks to, for a business to have its own accounts, and which you can draw upon them or write bank checks from them. What is the difference between a sight draft and a time draft? A sight draft simply means that the check is payable upon immediate presentation to whichever party you are paying it to. Whereas a time draft simply means that it cannot be cashed, cannot be surrendered for money until the time passes for it. So we sometimes have heard about a post-dated check that we will put a date on the check that is later than the present date. Well, it can't be cashed until that date occurs. So what is the real differences between negotiable and non-negotiable commercial paper? Well, with non-negotiable paper, the possessor steps into the shoes, that is, has the very same contract rights as a party that makes the underlying contract. Non-negotiable paper. So let's say, for example, going back to the car loan contract, that there's a provision in it that specifically states that it is non-negotiable. And so whoever made that would have the rights, certainly, to enter into making claims for a defective product against the party to whom is named as the payee. Now, with negotiable paper, which is the most common situation, the promisor must pay the holder of it regardless of any underlying contract rights. So let's go use my example again of the car loan contract. that the automobile dealership sells to another creditor. Well, this creditor, with this negotiable document, would not be subject to the underlying contract rights. So, assuming for the moment, of course, you're going to have you have a defective car for some reason. Clearly, you would still have rights against the seller, right, or the manufacturer, but not against the new creditor who has taken the commercial negotiable paper in his own status. What are the requirements for a document to become a negotiable commercial paper? Well, first we have to deal with it in writing, right? It has to be a document that is in writing. It's got to be signed by the maker or the person whose account it is being drawn on. The instrument has to contain an unconditional promise or order to pay without any conditions. The instrument must state certainly a specific amount of money. The instrument has to be payable on demand or at a specific date. If no date, then it is payable on demand. So, for example, when we write a check, right, we make it payable to a party, and we write today's date on it, and then give it to that party. Well, they can immediately cash it. It is immediately payable. But if you were to post date it, that is, give it a date later than the present date you make it, then it wouldn't be cashable, if you will, until that date arrives. Now, clearly with most of our checks, we put somebody's name as the payee, right, to whom it is payable. But if we were to leave it blank or to write bearer on it, then whoever happens to be holding the instrument can cash it. All right? You've heard of bearer bonds before, which simply means that whoever the possessor of the bonds are can have them cashed, assuming for the moment they are negotiable as of a certain date. So we know from our own check writing experience that in order to be a negotiable, an instrument has to state payable to the order to. And that's why your checks start off, saying that to a named, party, whatever creditor you put in there. Now, bearer paper doesn't have anybody's name on it, can be redeemed by any holder in due course. So it can be payable to cash or left blank and become bearer paper. So just like checks, if you don't fill in anybody's name on the check, then it's going to be essentially payable to cash, right? Whoever happens to possess it. What about checks in which we have put that they are payable to more than one party? So, for example, when we use the conjunctive word and, payable to Mr. and Mrs. Gregory Huckabee. By putting in the word payable to Mr. and Mrs., the and is conjunctive, which makes it a requirement that the payable party has to have the signature or the endorsement of both parties, Mr. and Mrs. Now, let me distinguish that from a check that is written payable to Mr. or Mrs. Gregory Huckabee. So that would make it either I could cash the check or my spouse could cash the check. But there wouldn't be a requirement for both our signatures, which would be required if the magic word and were used, okay? Now, we all have at one time or another been slovenly in writing our checks, right? And so we've created ambiguities between the numbers on the check or the note and the written language. So one naturally asks the question, so which takes precedence in this confusing ambiguity situation? Do the words take precedence over the numbers, or do the numbers take precedence over the words, boys and girls? Well, handwritten terms prevail over printed terms, and you're going to find that words take precedence over the numbers, okay? Because they are more clearly handwritten manifestations of our intent. Why do typed terms win over printed terms? Well, that's just a decision that has been made under Article 3 that typed terms on a draft or negotiable instrument will win over printed terms. How about when there's a space for interest on a document? In other words, the interest rate hasn't been filled in for some strange reason. Well, in that rare case, if that were to happen, then the South Dakota state rate of judgment, or the judgment rate of interest, would automatically be inferred. And our state judgment rate of interest is 10%. So I really haven't run across many interest documents that have left that blank. That usually is something that's always filled in, but again, the UCC provides for fill in the situations to keep instruments alive. We've got our case that is in our text, our hard copy text, the Blasco versus Money Services case involving a bankruptcy court. So it's a good illustration of what we're talking about here today. So we've got Blasco, who's borrowed $500 from Money Services Center to repay the loan. They gave a check for $587.50 to be cashed in 2 weeks. So we would call that a time draft, right? Now, Blasco was paying 17.5% for a 2-week loan. Now, before the Money Services Center, the creditor could cash the check, Blasco filed for bankruptcy. So even though the creditor knew of Blasco's filing, the creditor deposited the check. The numerical amount on the check was written $587 and the $50/$100. So what's our question here? Was the check negotiable despite this ambiguity here? Well, if the words, although ambiguous, do not contradict the amount shown in the numbers, the words do not prevail in the amount. So applying it to this case, since the numerical amount is not ambiguous, it is possible to determine the fixed amount of the money payable to the defendant by referring to the face of the plaintiff's check. So the court held for the creditor here, right? No problems. Negotiation is a commercial paper term of art that simply means, look, we are transferring the commercial paper to another party other than the party that obviously issued it. So in order to be legally negotiable, what has to take place? Well, the order paper, let's use a check for example, has to be endorsed and delivered to a transferee. So we, on many cases, have written that a check be payable to another party, and then that party, in turn, upon receiving the check, endorses it, and then they can deliver it to another party for the purpose of having it cashed. We all know what an endorsement is, right? Signature of the payee. But, you know, there are a number of types of endorsement. Blank endorsements. What are blank endorsements? Well, the payee signs on the back of the check without designating another payee. But once a person is signed on the back of the check and transfers it to another party, that new party can cash it. But what about special endorsements? We've done those before, right? Where we have a payee who signs on the back of the check, for example, but identifies a particular person to whom it wishes to transfer the check to and making it payable. So it's not unusual sometimes to see a variety of endorsements on the back of a check, and whoever's the last person named on it would have the right to cash it. In terms of restrictive endorsements, we've all used those before on checks before. For example, writing a restrictive endorsement to the effect for deposit only means the check can only be used for the purpose of depositing into a bank account. It cannot be cashed instantly. So that is a limitation specified by the payee, right? So you endorse it on the back, but you endorse it on the back of the check by saying for deposit only to whatever bank or institution they wish to have it deposited to. All right. Now follow me on this because this is going to take some careful consideration here when we start talking about holders in due course, known as HDCs. All right. So who and what is an HDC? An HDC is a party involving commercial paper who has an automatic right to receive payment for a negotiable instrument subject to, and we'll cover these, to a number of real legal defenses. Now, the HDC requirements are determined at the time they receive the instrument, the commercial paper. So let's go back and use my car loan commercial paper example. Okay? So when we have a debtor who has signed a loan document that a creditor now possesses, is that creditor a holder in due course? Well, the creditor may very likely resell that loan document to another creditor. Not unusual at all. So, what must the new creditor do in order to lawfully receive the negotiable instrument? Well, as you would imagine, they first have to possess the instrument, okay? They have physical possession of it. Second, they have to give value for the instrument. Something of value has to have been exchanged. And so in my loan document example, almost always the new creditor will have probably given, some type of discounted value to the former creditor. The holder in due course, the new creditor, must acquire the instrument in good faith. We've heard that before, as determined by the subjective test. Did the holder in due course believe the transaction was honest in faith? Did the new creditor believe that they received the loan instrument, the commercial paper, from the former creditor in good faith? Did the transaction appear to be commercially reasonable under the circumstances? And that the holder in due course, the new creditor, has no notice of any outstanding claims or defenses, such as the instrument, the loan document is overdue. That is, that there are already debtor payments that have not yet been made because they're overdue, or that the instrument has been dishonored. Ooh, that the debtor has refused to make payments, or that the former creditor has dishonored the instrument because there's something wrong with it. Or how about this one? So let's take, for example, altering, forging, or some type of incomplete area of the instrument that is missing. So clearly, if there's been a forged signature on the negotiable paper loan instrument, that certainly would be an outstanding claim or defense, right? Now, let's look at the Hartford Accident Indemnity and American Express case to illustrate a little bit what we're talking about. So we've got the manager of the Avon Export Products, and as manager of Avon Export Products, we've got Scalco, who's got authority to issue checks up to $25,000 on his signature alone. Now, for nearly 3 years, this agent of Avon Export, had been using his authority to steal, get a load of this, $162,538 by altering the names of payees to pay his personal debts. Obviously, Avon was not happy with this and sued the recipients of the checks of the funds. Now, the trial court ruled that the payee defendants were entitled to keep the funds because they were holders in due course. They didn't have any notice at the time they received the checks from Scalco that he was embezzling. They had no notice of that. And so they claimed, hey, we're HTCs. We received the money in good faith because he used it to pay his debts. We didn't know that he was stealing the money with these checks. And that's the question. Were the defendants holders in due course? Our simple rule is to be an holder in due course. A party's got to take the instrument without notice that it is overdue or that it's been dishonored of any defense or claim on the part of any person, which we just looked at. So parties that take commercial paper for value are not bound at their peril to be on alert for circumstances which might possibly excite the suspicions of wary vigilance. Thus, we got the defendants didn't have notice of Avon's claim or the embezzlement. And so the judgment of the trial court holding that the defendants were not liable or aware of the claims is valid. The shelter rule, the shelter rule. Do we all need to know about the shelter rule? Of course we do in commercial paper. What is the shelter rule? The holder in due course transferor passes on all his rights when the instrument is transferred, even if he's not a holder in due course himself. So let me give you an example because this may be a little confusing. So let's take Cigna Insurance Company sends a claimant a check for $400. Now the claimant falsely informed Cigna he never received the check. So Cigna stopped payment on the check. But the claimant took this check to a market and used it to buy goods. This is the check that he claimed had been lost or not received. But when Cigna stopped payment on the check, the market received the check back stamped ISF, insufficient funds, right? So the market then sold the insufficient funds check to Triffin. Now, Triffin specializes in buying insufficient funds checks. So Triffin sued Sigma, even though Triffin was not a holder in due course, right? Because he was aware of the check being dishonored. Now, under the shelter rule, the market's holder in due course status was transferred to Triffin because the market didn't know the check was dishonored until it came back insufficient funds, right? So it originally was a holder in due course. And so its holder in due course status was transferred under the shelter rule to Triffin, who is entitled to payment. Okay, so you see how the shelter rule works? All right, now let's talk about real and personal defenses. Why are they important? Because real and personal defenses are valid against a holder, but only real defenses are valid against a holder in due course. So, for example, Triffin in our previous case was a holder, not an HTC. Whereas Sigma was, whereas the market was a holder in due course. So the following real defenses are valid against both a holder and a holder in due course. Forgery, bankruptcy if the debt has been discharged in a bankruptcy proceeding, underage. Most states you have to be age 18 in order to be able to engage in contracting and assignments and things of that nature. Alteration of amounts. So these are all real defenses. Duress, mental incapacity, or illegality. These are all real defenses. Fraud in the execution. That is, the issuer was tricked into signing the instrument, for example, without knowing what it is. So, example, a foreign national that doesn't speak or read the language, and yet you have him sign something, that would be fraud in the execution. Having him or her sign a instrument. Now, these are personal defenses, and they're not valid. These are not valid against a holder in due course, but they're valid against an ordinary holder. So, a prior payment, that is that the note has already been paid off, and so the debt no longer exists. So, this wouldn't be valid against a holder in due course, but it very well could be valid against an ordinary holder. Unauthorized completion, blanks filled in by another without authorization. Fraud in the inducement, signing of a promissory note is based on a fraudulent action, that is, writing a check to pay for stock or an item that doesn't exist. Or non-delivery, that's where we have fraud, right? Or non-delivery, when an instrument, for example, a bearer instrument, is stolen and sold to a holder in due course. So let's take a look at this case. So we got Ventures versus Jim Ward and Associates. We got Ventures that borrows $3 million from Ward Associates to purchase property in California. Now, Creative signed promissory notes payable to this creditor, right? And so the creditor sold the entire loan to 54 individual investors. Now, the creditor kept possession of the notes, but he paid the investors their share of the loan payments. Now, California state law capped interest rates on loans at 8%, unless the party was a licensed real estate broker, which the creditor was not. So when Creative learned of this, they sued. When the debtor learned of this, they sued the creditor and the investors to obtain a refund of all the interest that exceeded the state cap of 8%. Now, the investors argued that they were entitled to keep their interest because they were holders in due course. The trial court found for them. Now, what's our legal issue? Of course, were the investors actually holders in due course and thus entitled to keep the interest paid on the loan, which would be up to 8%. So, under the California UCC, and a holder takes his or her interest free of many defenses, including the defense of usury. In order to be a holder in due course, however, one must be a holder of the instrument which the investors did not hold, right? Remember, JWA was holding the notes. He had possession of the notes, and he just paid the interest on that. So that reversed the judgment of the trial court, and the investors ended up losing in that particular case. Consumer paper. So what is consumer paper? Let's take, for example, promissory notes given by a consumer to purchase consumer goods. So buying a refrigerator on time would involve a consumer signing a promissory note, right, to a creditor, purchasing the refrigerator, the stove, whatever the big ticket item is, for X amount of money each month at X amount of interest. Now, the Federal Trade Commission, better known as the FTC, requires that all promissory notes and consumer contracts must contain this boilerplate language. Any holder of this consumer credit contract is subject to all the claims and defenses which the debtor could assert against the seller of goods or services obtained with the proceeds hereof. So, what does that mean? It means, assume for the moment the refrigerator were defective. Well, it means whoever owns that consumer contract, whatever creditor owns that, is going to be subject to claims for defective products from the debtor. Okay? So, in sum, as a consequence, no one can be a holder in due course when financing the sale of consumer goods if affiliated with the seller. Okay? So if the creditor is affiliated with the seller and that they have some type of arrangement, agreement, contract in which the creditor, buys from the seller, all his commercial paper, well, guess what? He can't be an HTC because it involves a commercial contract. Okay, our last case here is the Altoona versus Nescor case. So we got Vladis, who's a salesman for Nescor. That was a home improvement company. He convinced the poor Altoonas to sign a consumer credit contract with Nescor. Oh, so you know what's coming, right? The Altoonas would pay for the improvements by installments. Now, Nescor assigned, that is, sold the contract to another creditor called First Consumer Credit, which reassigned it to the money store. So it's not uncommon in commercial paper to see the commercial paper transferred, that is, resold numerous times to other creditors. Now, clearly it gets discounted each time for cash and then gets, sold on, and the debtor has to pay whoever the new creditor is. Now, the contract contained the Federal Trade Commission's required language. A Connecticut statute requires that no such home improvement contract will be valid or enforceable unless it is entered into with a registered salesman or registered contractor, which Vladis was not. Didn't comply with state law. Is that important? Well, unsatisfied with Nescor's home improvement work, the claimants here stopped payments, and of course the creditors sought to foreclose on their home, claiming that the creditor was a holder in due course. And so that's the question. Does the creditor have a legal right as a holder in due course to foreclose? Well, what's our rule of law here? Nescor's material non-compliance with the state law renders the home improvement contract invalid and unenforceable and precludes it from enforcing the consumer credit contract against the Altoonas. So not being a true holder in due course, the creditor is subject to those same claims and defenses under the very language of the contract with the plaintiffs. So the creditor can enforce the consumer credit contract it holds by foreclosing on the plaintiff's property for non-payment. So the plaintiffs win. The creditor loses because this is a consumer contract. Okay, boys and girls, we've done it, and nobody was injured. How about that? Okay, well, I'm going to have to get my snow shovel out there and try and fight my way to get my car out of the snowdrift. But I know most of you are in Florida and whatnot. But in any case, be thinking of your poor professor freezing to death up here at the North Pole in Vermilion, South Dakota. Hey, stay well and stay in touch. To be continued. Bye-bye.